this meeting to order. Welcome to meeting number 25 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the motion adopted on February 8th, the committee is meeting to resume its study on the government's obligations to the victims of crime. Today's meeting is taking place in hybrid format pursuant to House Order of November 25th, 2021. Members attending in person in the room and remotely using the Zoom application. The proceedings will be made available via the House of Commons website. For those on Zoom, you have a choice at the bottom of your screens of either floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. Before I welcome the witnesses, I want to give my condolences to Miss Neville Lake. I believe of the understanding of the passing of her husband, I wish to, on behalf of the entire committee, give my condolences to her, and therefore she's not going to be appearing today. And to the witnesses coming forward, I know this is a very sensitive and personal subject for you guys, so take your time on it, although I will ask you to stay within the 5-minute parameters. I do have little cue cards, which I will raise when it's 30 seconds remaining, and when your time's out, so I just ask you to conclude, and then that I don't like interrupting if I don't have to. And in the interest of time, because we've started a little late due to votes and member statements for the House Leader, for the opposition leader, we will do 2 45-minute rounds, and we'll try to go to 6. I don't have unanimous consent, but I should have it. I think we're just looking for a filler for somebody, so we should be able to go to there. So beginning, I think in our first round, we have the Honourable Pierre Hugues Boisvenu, Senator, thank you. And we have from the Families for Justice, Marquita Collis, President. I think you're online, yes? And I believe you're from Surrey, if I'm right.
Correct.
Yes, so welcome from my hometown. Also, Holly Lucier, a paralegal, and we have from the Women's Law Association of Ontario, Jennifer Gold, lawyer and director of the board. So I'll begin with Senator Boisvenu for 5 minutes.
Thank you, Chair. Would like to inform you that I will have to leave very early because I have to be at the Senate at 5 o'clock. Mr.
Yes.
Lametti is there. And as Deputy Chair of Justice Committee, I have to be with him at that moment. Merci beaucoup.
Thank you very much, first of all, for the opportunity to address you today on this study of the federal government's obligations to victims of crime. As most of you know, as a result of the rape and murder of my daughter, Julie, by a repeat offender 20 years ago tomorrow, and the lack of legal rights for victims of crime and their families at that time, I have since dedicated my life to the recognition, enhancement, and protection of these hard-won rights so that no victim will ever feel abandoned by our federal institutions and our justice system. The Canadian Victims' Bill of Rights, which I personally contributed to for its adoption in 2015, was made possible by the leadership of Mr. Stephen Harper. This bill is essential for the recognition and protection of victims' rights. I would like to call upon members of the committee regarding the improvements the federal government must make. First, I would like to address the first issue, which is the lack of consideration the government is giving to the position of ombudsman for victims of crime. The position has currently been vacant for 9 months already, though the end date of the contract was known for 3 years. In 2017, it was vacant for almost 11 months before it was filled. This role is crucial in federal institutions for victims, ensuring that the government fulfills its responsibilities. It is also the media voice for victims so that the Canadian public can be made aware of the many issues that need to be addressed by the government. The lack of an ombudsman to voice the anger and the lack of respect for the rights of the families of victims of the Nova Scotia mass murder regarding the public inquiry is an example of this. To avoid a repeat of this scenario, the independence of the victims' ombudsman should be imperative, and legislation should be passed to make the ombudsman an agent of parliament in the same way as the correctional investigator, which is the ombudsman for criminals. Finally, the ombudsman should be the guardian of the victim's Bill of Rights and have sole jurisdiction over processing of complaints from victims of crime. Importantly, and in support of my point, in 2017, Bill C-343 was tabled in your House, and all parties supported it except for the Liberals, who were opposed to making the positions of victims ombudsman and criminal ombudsman equal. I would now like to turn to a second topic, the 5-year review of the Canadian Victims' Bill of Rights. Unfortunately, and as you know, this bill should already have been reviewed in 2020, and this further delay sends a negative message to victims. This is true despite the fact that the government has had obligations since 1985 under the United Nations Declaration of Basic Principles of Justice for Victims of Crime. Currently, the CVBR does not include all of the rights that are identified in the UN Declaration, specifically regarding compensation and services that victims should receive, such as medical, psychological, legal, and social assistance. The final report of the 2020 review of Canada's criminal justice system shows that victims still find it very difficult to report their crimes to the police for fear of retaliation or fear that their cases will not be taken seriously. And once they are inside the justice system, they are victims of a lack of compassion and respect. That is why this 5-year review is so important, because it would address these situations by correcting the gaps in the Canadian Victims' Bill of Rights, or the CVBR, that are harming victims. The 2020 Charter Progress Report by the Federal Victims Ombudsman's Office makes 9 specific recommendations for charter change, 2 of which I believe should be addressed as a matter of urgency. First, when victims' rights are not respected, victims have no recourse to the courts. To remedy the problem, the first recommendation of the report proposes to allow victims to appeal to the courts when their rights are not respected. Second, with respect to the enforcement of restitution orders, and this should allow any victim in whose favor a restitution order is made is entitled to assistance in recovering the amount awarded. And since 2015, I have been waiting for the Government of Canada to take a legislative initiative to improve victims' rights. An example is the right to protection for women who are victims of domestic violence. Is it normal that in 2022, when modern means exist to better control the behavior of violent men, that these women who denounce crimes do so at the risk of their lives, while governments are encouraging victims to denounce crimes? Is it normal that a murderer can, even once incarcerated, publish on social media pictures of themselves with their victim, and that families have to fight for months against these social networks to make them act? This is where the Charter should have been improved if you were responsible for the Victims of Crime Ombudsman function. And when I say you, I mean the Parliament of Canada. In conclusion, ladies and gentlemen, 20 years ago, victims decided no longer to remain in their prison of silence, to speak out and demand nothing less than to be treated fairly, just as the accused are treated fairly under the Canadian Charter of Rights and Freedoms. Victims and their families do not want more rights than criminals. They want and deserve the same rights, and it is up to this Parliament to recognize that. Thank you, and I will be happy to answer any questions you have if I have the time.
Thank you, Senator. I appreciate your time. Next, we'll have the Families for Justice, 5 minutes between Marquita Collis and Holly Lucier. The floor is yours. Either way.
Honorable members of Standing Committee on Justice and Human Rights.
Thank you very much, honorable members of the Standing Committee on Justice and Human Rights. Thank you for allowing me today. Sorry. My name is Marquita Collis, and I'm the founder and president of Families for Justice. I am here today representing thousands of Canadian families who have lost our children and loved ones killed by impaired drivers in Canada. On May 3rd, 2011, my 22-year-old daughter, Cassandra, was killed by an impaired driver. My daughter was driving home after coaching a softball game, and she was stopped at a red light and had the right of way to make a left-hand turn. As she waited for traffic to pass, a white van came speeding down the curb lane. The stoplight for the van had already been red for 12 seconds. The van accelerated the last 500 feet of the intersection, got airborne over railway tracks, and slammed into my daughter's vehicle. She was killed in a catastrophic collision when she was T-boned in the driver's side door. Cassandra was crushed to death by 3,000 pounds of steel crashing into the side of her at 103 kilometers an hour. The driver then fled the scene of the collision. and the driver was 2.5 times over the legal limit to drive. And sadly, instead of becoming a teacher that she had dreamed of being, my daughter became another statistic of impaired driving. She lost her life because another impaired driver made the willful, reckless choice to drink and then drive while being impaired. My family and I received a lifetime sentence of being without our daughter, and sadly, Cassandra received a death sentence. Impaired driving is the #1 criminal cause of death in Canada, and each year, impaired driving leaves a terrible trail of death, injury, heartbreak, and destruction. From that point of view of numbers alone, it has a far greater impact on Canadian society than any other crime. On average, between 1,250 to 1,500 people are killed each year in Canada, and thousands more are injured. In terms of deaths and serious injuries resulting in hospitalization, impaired driving is clearly the crime which causes the most significant social loss to this country. And since the legalization of marijuana in 2018 by the federal government, we have seen drug-impaired driving collisions rise by 43%. The percentage of Canadian drivers now killed in vehicle crashes who test positive for drugs now exceeds the number who test positive for alcohol. Criminal victimization of crime is a frightening and unsettling experience for thousands of Canadians, and the victimization is debilitating. And the efforts can often be long-term and difficult to overcome. Not only do we suffer physically, emotionally, and psychologically, financially from our victimization, but we are also often burdened by the complexity of the criminal justice system. I have spoken with hundreds of families who say they felt re-traumatized after going through the criminal justice system. They never felt their needs were being addressed or listened to, which in turn made their grieving process last so much longer. Individuals who are killed never have a voice or get to speak of the trauma they endured, and their families are trying to seek justice for their loved one. The families wait for months or even years for Crown to approve charges. Then they must go through numerous court proceedings, and which can take years due to postponements, due to lack of judges and court availability. Then there are plea deals made, many times where the charges are dropped down to a single charge altogether. When the accused finally gets to court, it doesn't seem like the accused is on trial. It seems like the investigation is on trial and the accused has more rights than the victims. If the accused is convicted at all, they are sentenced by using case law from previous cases where a similar sentence was given out. Often these sentences are so low, the accused is back out in the community in just a few days or months. And we have seen cases take longer to go to trial than the actual jail time given out, even when they were serious offenses. And families feel re-victimized as the accused has paid little debt to society. Canadians have begun to doubt not only the safety of their surroundings, but the fairness and efficiency of the justice system set up to protect them and their property. And Canadians would like to see changes to Canada's criminal justice system. Canadians feel there is several justice issues, including confidence in the system, crime rates, and parole. The focuses should be on special aspects of the criminal justice system, particularly sentencing and correction issues and assistance for victims. Canadians believe that the main purpose of the courts and our criminal justice system is to protect society. And Canadians believe that the system should act as a deterrent to criminals and that it should function to punish offenders who commit crimes against society. And sadly, that is not the case in our Canada by our current justice system.
Thank you.
Offenders are not being held accountable.
Thank you, Ms. Koulis. We'll try to get more of your statement in the questions that arise. Next, we have from the Women's Law Association of Ontario, Jennifer Gold. Jennifer Gold, for 5 minutes.
Thank you. I'm the past president of the Women's Law Association of Ontario. Since 1919, the WLAO has been dedicated to empowering women in the legal profession by providing a collective voice and advocating for equality, diversity, and change. Our members practice in various areas of law, and we draw upon their expertise when we are asked to make submissions. I have practiced family law for over 20 years and represent survivors of family violence. In addition to my work with the WLAO, I am a board member of Legal Aid Ontario and Pro Bono Ontario. My fellow board member and chair of our advocacy committee couldn't be here today, but she practices criminal law and contributed to these submissions. I also speak to you from my own personal experience as the child of a survivor of family violence. I spent a significant portion of my childhood witnessing that violence against my mother. I also witnessed my father's struggles with mental illness, addiction, and his experience with racism as an immigrant. By now, you've heard about the challenges and barriers faced by victims of crime and the inadequacy of our current supports for them. It is a gender issue, as most victims of crime are women, and my remarks today, however, will focus on solutions. In studying the government's obligations to victims of crime, including the vacant position of the Federal Ombudsman, and reviewing the Canadian Victim Bill of Rights, this committee has an opportunity to create transformational change. What is meant by that change? The WLAO seeks change that is systemic, that aims to alleviate such crime in the first place, and truly serves victims and their children. A solution that does not consider the entirety of the issue at hand can be akin to treating the symptoms of the disease and not the cause. Many societal problems are symptoms of larger systemic issues. For instance, family violence against women is a symptom of patriarchy. So in considering solutions, we need to employ a lens that examines society in general and the interactions of the entire justice system broadly alongside individual issues. Yet we do need those Band-Aids to stop the bleeding while we find a cure. So some of the solutions involve: 1, supports to navigate the current system. One of the issues for victims is the lack of information readily available to navigate the justice system and understand court processes. Some ideas to remedy this issue are: 1, scale up the services and support offered by victim services and create a voluntary information program, similar to the mandatory information program for family law cases that provides guidance for litigants through the court system. Additional support could include a 24-hour counseling or resource hotline for victims. This could address the limited services that are available in remote and rural communities. 2, fund counseling for victims, their children, and survivors impacted by the crime. When possible, recover the cost of such services from the accused. 3, utilize and fund provincial legal aid systems so that eligible victims can obtain representation. As an alternative to full representation, 4-hour certificates can be given to victims to obtain a lawyer to learn about the court process and criminal law itself. Additional funding could be given to legal aid programs so that family lawyers can pursue the tort of family violence. And I've cited the case Ahluwalia and Ahluwalia. Additional funding can be given to legal aid programs, legal clinics to assist victims with restitution for other types of cases. Use technology to scale up services so that communications with victims can be tracked within an organization. For instance, Pro Bono Ontario uses software called Salesforce to track calls through to their centre. Amend sections 6 to 8 of the Victims' Bill of Rights so that the rights enshrined in those provisions do not put the burden on the victim to request information. Victims from historically marginalized groups may not feel comfortable making such requests. And in addition, placing this burden on traumatized individuals may not be practical. Create a federal statute to compensate victims of crime. Options that allow victims to have some influence on the process is another solution. In our current systems, victims are framed as the object as opposed to the subject. In order to address the objectification of victims, the following may work. 1, the option to be added as a party. 2, allow the victim to opt for restorative justice for both the accused and victim. And 3, increased opportunities in the process for restorative justice programs. Regarding the Federal Ombudsman, This position should be filled expeditiously while ensuring a proper search is conducted. That office should be inclusive and diverse. I have other suggestions for big picture systemic considerations, but I see that I'm at the end of my time. Thank you.
Thank you, Ms. Gold. I think, Ms. Lucier, I think we've asked if you could submit your remarks and to the clerk, and we'll have those composed in it because your time was shared with Ms. Coulias. But people may ask questions of you. There's, by all means, are able to do that. I will begin by the first 6-minute round with Mr. Moore.
Well, thank you, Mr. Chair, and thank you to all of our witnesses for appearing today. This is a really important study that we're doing on how we can improve the laws in Canada and services as they pertain to victims. And I do want to turn it over to you, Holly. I know you've prepared some remarks, and I know you're here with a strong message to tell. You've written, I had met with you in the past, and you told me that you'd written 3 victim impact statements in just the last 2 years on behalf of your daughter. So it came up in the discussion already from panelists about the re-victimization of the process that family members go through. So I'll turn it over to you to answer that question, maybe elaborate on how the process currently re-victimizes families. But if you want to present a bit from your prepared remarks, feel free to do so at this time as well.
By an impaired driver, and she had been crossing a road in a marked lit up crosswalk, and she was blindsided by an F-150 pickup truck. The time that it took our offender to eventually be convicted was torture for our family. It was a long, drawn-out process. It took 2.5 years for the offender to plead guilty. A month following the sentencing of our offender, he applied for day parole. We had just barely made it through the sentencing hearing after waiting 2.5 years in complete devastation. Our lives were bankrupted of every imaginable morsel that you can think of. And then we get to sentencing. He gets 3.5 years, and a month later applies for day parole. I literally wrote 1 victim impact statement for sentencing, and a month later was writing a brand new statement for parole. There is no support. There is no, victims and their families are left to find advocates outside of the court processes. They are left to find advocacy and help from people outside of our own institution, our own establishment. I don't see the help for victims and their families that I see that for the offenders. I don't see that. The current legislation creates unfair hardship for victims and their families because they aren't even recognized as victims of a violent crime. We're considered victims of a motor vehicle incident. They aren't recognized as victims of a violent crime by the courts or by provincial services for victims, and because of that, it's causing undue hardship, even more so to victims and their families. There needs to be a bill brought forward for victims' rights that would allow victims and their families to be recognized for the damages and suffering that they endure. It is time to change the narrative for victims and their families. It is time to change legislation and the entire way that impaired driving is regarded so that families don't have to keep living through this in the name of justice. I think, there's a number of things that could be changed in our system to provide better supports for victims and their families. If you look at the accused, if you look at offenders, they are provided free counseling as soon as they enter a guilty plea. But there's no free counseling for victims and their families. We have to find that on our own. And if you don't have the resources, and if you've lost your job, and you can't afford to pay to pay for your own family anymore, or keep a roof over your head, you can't afford therapy. It's a hardship. It's a hardship that doesn't have to look like this for victims across the board. Families don't have to suffer like this if we had better supports available through victim services. The time it takes for matters to go through the courts, it's unnecessary. If the courthouses had better triage of their matters and actually had a person that was looking at the matters that are set down for trial by the Crown, we would be able to triage the courthouse files and get matters out of docket. We're taking too much time of the courts, and it's actually costing innocent people and the families that are waiting.
Thank you, Holly.
Thank you for your time.
You and Marquita both, I met with you in the past, and I'll turn this over to either one of you to answer. But you mentioned some of the supports that victims need and how you've found that was totally lacking, and that led you to become part of the organization that you're with now to help other families that are going through similar things. How should the system that you already recognize provides a lot to offenders, what type of services do you think victims' families are most in need of right now in Canada?
I think families going through the court processes are in need of mental health supports, financial assistance. We need to see our rights being recognized, and but I think a big part of it is the financial assistance for families and also the mental health supports, not to mention the advocacy for their matter, for how to, when, you know, like victim services will walk you through, you know, when your court dates are, when the next, you know, appearances are, you know, sort of what to expect for those types of things. But then you're sort of left on your own. And for many of the families, when they go into court, they are blindsided. And they come to me afterwards. I have spoken with many families, my own included, and many others that, you know, they come out of court, they don't understand what just happened. They don't understand the process. They don't understand the decisions that were made and why. And there's not really anybody there to follow up with them. And so I think there's a number of things that we need, ranging from the supports, from the mental health to the financial assistance, to proper advocacy, so that our own establishment is helping the victims and their families, and it's coming from within, not on the outside. Because it sends a dangerous message to us that offenders' rights are more important and that their lives are more valued than ours. And yet we're the ones that are going through this. We're living it.
Thank you, Mr. Moore. Thank you. Ms. Dillon, for 6 minutes.
Thank you, Mr. Chair, and I'd like to thank all the witnesses for coming today and sharing your very painful stories with the committee. I'd like to start my questions with Mrs. Gold. As you know, recently the Supreme Court rendered a decision about extreme intoxication, and this has caused a lot of concern for victims' organizations. And last week, the government tabled legislation to address what the Supreme Court said. What do you think of the government's swift action on this issue? Thank you.
I applaud the government's swift action on this issue. I'm aware of the decisions in R versus Brown and R versus Chan. Our association was at the technical reading of that bill, and we, at this stage, all I can say is that we approve of the direction that this government is going on. I didn't believe in a separate defense of extreme intoxication. You know, at this point, that's what I can say. I need to take probably a closer reading of the bill since it just came out.
Thank you very much for your frank answer. You also spoke about racism, systemic discrimination. Over the last few months, our committee has studied Bill C-5, passed it, and it aims to address this bill. It aims to address the overrepresentation of Black and Indigenous and people of color in the criminal justice system. We've seen some people saying that the bill is too soft on crime and pitting community safety and victims' rights against constitutional rights and common sense, you know, a criminal law policy. Do you think this bill would address the overrepresentation issue and that it necessarily goes against victims' rights when we talk about trying to balance both?
I can't speak to the bill specifically because I haven't reviewed it, but however, speaking on a higher level about these issues, there are rights that need to be balanced. For instance, there was recently a report done in the City of Toronto regarding the targeting of Black and Indigenous people. They're more likely to experience having a gun pulled on them when unarmed as opposed to somebody who was white. And I think that speaks to why we have a system where, Indigenous and Black people are overrepresented in our jail systems. However, with respect to victims, they also, I believe, have a charter right of security of the person that also needs to be balanced. And so you're talking about some pretty big issues here, but I think we have to have a recognition that our system has flaws with respect to systemic racism, patriarchy, and the fact that little attention has been paid to victims. I'm not suggesting that we not fund legal aid to represent offenders or the accused. I'm just suggesting that we provide some additional funding to support victims and to give them agency in the system.
And what other things would you like to see to help victims?
Well, I was, I'd made some suggestions, but I didn't get a chance to speak to some of the larger systemic problems and maybe where they flow from. And what I'd like to see this government move in the direction of is eradicating poverty, implementing greater support for people with mental illness and mental challenges, implementing greater education and training for the judiciary and the police, providing supports for the next generation, taking into account intergenerational trauma, and strengthening gun control, such as Bill C-21. I think this government has an opportunity to create transformational change, and we applaud the steps that in the direction of Bill C-21 and Bill C-28 reflect, and the recent amendment to the Judges Act and the Criminal Code that requires judges to be trained on sexual assault law and the social context. Thank you.
Thank you so much. And in your opinion, this report that just came out, from what we saw in it, do you think that there are some immediate measures that can be taken to try to help address issues of systemic discrimination?
Which report? I'm sorry.
The one you spoke about that came out last week about.
In the City of Toronto.
Yes,
okay.
Exactly.
I think data is always important. It's now what you do with it. So I'd like to see action on that.
Perfect. I thank you so much. That's it for me for questions.
Thank you, Ms. Dillon. Next, we'll go over to Monsieur Fortin.
Merci, Monsieur le Président.
Thank you, Mr. Chair. I would also like to thank the witnesses for being here with us today. This is an important topic, and your stories will be very helpful to us. Mrs. Gold, I would like to begin with you. Senator Boisvenu was here earlier, but he had to leave us, and he was proposing that the Ombudsman should be a direct agent of the House of Commons rather than the Department of Justice. What do you think about this? In your opinion, should the Ombudsman, and that post is currently vacant, but once it will be filled, would it be more effective if it were under the House of Commons? What is your point of view on this matter?
Unfortunately, the senator had to leave, and it was his proposal. I can't say that I know the workings of the House of Commons and Departments of Justice well enough to speak on that.
Merci, Madame.
Thank you, Mrs. Gold. Can you speak to me about your own personal experience with the person who was in the ombudsperson position, as we should say? It was a woman up until recently. You are part of the Women's Law Association of Ontario, so I'm assuming that at times you have been in contact with the person in that position. I would like to hear what you think works better, what works less well. What is your opinion on this position of ombudsman?
Unfortunately, I don't know the former ombudsman personally. I haven't had dealings with her in relation to the association. I could speak perhaps generally about my thoughts of that office, that it needs to be properly funded, first of all. It needs to be effective. And if you're going to expand the rights of victims in the Bill of Rights, there needs to be a corresponding expansion and agency with that office. It's lovely to write all these wonderful things, but if it's not being seen in action and if it's not being experienced by victims, it's rhetoric.
Merci.
Thank you. Earlier during your statement, you spoke to us, or I said you, but I think it was Ms. Lucier. You talked about the fact that, as we understand, victims of crime could benefit from time with a lawyer and may also need psychological counseling. You might be noticing that I'm asking my questions in French. It's not because I want to make things difficult for you, but as a member of the Bloc Québécois, this is something that we do to ensure that Parliament is working in both official languages and that Quebecers listening in find it easier to listen in French. So I hope that you don't take any offense to that, but I will be asking you my questions in French. So on this matter of resources that would be available to victims, so access to a lawyer is a good idea, access to psychological counseling as a support in certain cases as well. You work with the Women's Law Association of Ontario, and because of your position there, do you have an opinion on the suite of services that should be available to victims of crime?
Yes, and by the way, I love that you're speaking to me in French. We're in a bilingual country and with two official languages, and you're providing me with some challenges to recall some of my high school French, so thank you. With respect to a suite of services for victims, I have many ideas about that, but they would require greater input from victim services and legal aid service plans. And also, obviously, the budget that's available to fund these services. And I think, continued conversation with victims on how resources get allocated is really important. But as a family lawyer, speaking, I represent survivors of domestic violence. And just as Ms. Lucier said, they do not know what's going on in the criminal process. Quite often, as a family lawyer, I need to advise them about what the next step is and what it means and when they may see a resolution and what they need to do and who they should contact. And that's beyond the scope of my work. Quite often, I wear a social worker hat as well. But these are resources that victims need to navigate the system, especially in light of the pandemic when there's tremendous amount of backlog in the courts. Ms. Lucier's experience is even worse now. And hopefully that can be rectified with additional resources to the judiciary and other branches.
Présentement, lorsqu'une...
Currently, when a victim is involved in a crime, the Crown prosecutor, the person prosecuting the criminal, does that person have a closer relationship with victims? I've never practiced law in Ontario, so you know this better than I do, but what is this relationship with the Crown prosecutor?
I think it depends on the Crown prosecutor, firstly, but from my experience, there's a very limited relationship, hardly any. It's made very clear to the victim that the case is conducted by the Crown, and they have very little say about the process. I think conversations with victims quite often happen right before the court appearance because they're busy and overburdened. And so that's why there are victim services to help support victims through that process. But I don't think Crowns actually have the time to sit down with victims, and I'm not necessarily sure if they're best suited to. They may know the law, but they're not social workers, and it takes some competency to work with victims.
Thank you, Ms. Gould. Thank you, Monsieur Fortin. Mr. Garrison, for 6 minutes.
Thank you very much, Mr. Chair. And I want to start by thanking all our witnesses today for sharing their experiences as victims with us. And I know we've talked about the re-traumatization of the court process, but I think as members of the committee, we also acknowledge that appearing here today is also part of that. And I trust and hope that you have supports in place for that re-traumatization that's almost inevitable. I don't think any of us who haven't experienced it directly can fully understand the weight that comes with that. But I do want to thank all of you for trying to take that experience and turn it into something positive and turn it into positive change. And I know with some of the victims I've dealt with, it's one of the things that's helped them move forward is by trying to make sure that people don't experience the same thing that they did. So my thanks here are really very sincere. One of the suggestions we've heard already in this study is that we should move from victims having to request information to a system where information is delivered mandatorily. And so some people have said, well, there will be problems with that, and some victims might not appreciate that. And so I want to start, I'll start with Ms. Gold just for practical reasons here for a second. Do you think there's any problem with the mandatory notification of victims from the victim's point of view?
No, I don't. I think victims can choose whether they engage with that information or not, but at least people are being reached, especially people from historically marginalized communities who may not feel comfortable approaching government or various agencies. In the family law system, there is a mandatory information program for people going through separation and divorce, at least in Ontario. And so I don't see why a similar program can be available but voluntary for victims.
And I'll ask the same question to Ms. Callias. I'm just trying to get it on the record here. I think I know your answers, but I think because some people have raised those concerns, I'd like to hear from victims' organizations how they feel about mandatory program of information.
I think that would be wonderful for families. I mean, families have so many questions, and so many our questions are not seem to be ever answered. I think people will let you know the information that they're looking for, what they want, and what they need to be kept basically out of the loop of everything is even more traumatizing for families. They just want to be kept up to date with information and know what's going on and where this path of the criminal justice system is taking them. I don't think they'll ever get the full amount of answers that they need, but there's definitely more that needs to be done.
And Ms. Lucier, would you have a similar attitude toward mandatory information?
I think so. I know that, like with victim services, sometimes, they will call and ask you if you want the support. For a lot of families, they say no, but they actually don't recall having those conversations. And so I think the mandatory would alleviate that burden. I know for me, I had actually told victim services that I didn't need any support, and I actually have no recollection of ever having that conversation because I was right at the beginning. And so, having it be mandatory and having things follow up, I think would alleviate a lot of the later concerns that come.
I think you've just given us a very important insight into where some of those possible objections came from.
Yes.
So I thank you for that. One of the other things we heard again today, is the necessity of mental health supports. And sometimes we get a response from people, well, those are available to victims just like they are anyone else. And so I would like to ask about your experience. Not saying we don't need special services, because I would support those, but I guess I'm trying to debunk those who say it's easy for victims to go and get mental health supports elsewhere. I'll start maybe in reverse order, Ms. Lucier.
It wasn't easy. In fact, my therapy didn't come until this year. I went 3-4 years without the proper supports, without any sort of mental health intervention or the ability to even process the trauma. I ended up in an emergency state this year and going through a community program in my neighborhood, in my community that supports victims for different reasons, but mainly to do with violence and sexual assault. And I was able, because of a past trauma, I was able to get the supports from the program that I needed because of a past trauma, not because of this, when this should have been the priority to treat and to support.
I'm sorry that it took a past trauma to get you assistance in the current one. I think that's probably too often the story.
That is. Yes.
Ms. Callias, can I ask the same of you?
For myself, it took 3 years for me to get some therapy. The first therapist actually didn't work out well, and I had to go and find someone else for a second try. there isn't much when your loved one, especially, is killed by an impaired driver. There's really not anywhere to turn. Families just don't know what to do. Their whole world has just collapsed, and there doesn't seem to be much out there for them. And that's the really sad part about this. It's the deaths of our children and loved ones are not a normal car accident. I mean, impaired driving is a choice, and it's made by people who are reckless in their decisions, and they make the choice to drive while impaired. And all of our loved ones as well died by very violent deaths. And that's very hard for families, for parents to process. And there is not adequate resources or even therapy out there to deal with this, because most people don't have to deal with it. But it's amazing, on the other hand, that we lose between 1,200 and 1,500 people a year to this crime.
Thank you very much. I'm out of time.
Thank you, Mr. Garrison. Now we'll just, in the interest of time, we'll just condense the next round into 2 3-minute rounds, if that's okay, beginning with Mr. Richards for 3 minutes.
Thank you. I'm going to start with Ms. Collius and maybe Ms. Lucier as well. You both made statements that I think really struck me. I've heard statements like them before, but certainly they struck me, especially when combined with you telling your very personal, tragic stories, and it really pulls at our hearts, and I hope it did that for everyone, and I'm sure it did. But the statements that you made, Ms. Collius, you said, feels like the accused has more rights than victims. Ms. Lucier said something similar, talking about the offender's rights being more valued than the victims. And I both kind of elaborated on those statements by indicating the injustice of whether it be short sentences that don't really seem to fit the crime, whether it be the complexity and confusion around the legal and court processes, or the lack of information. There was a lot of factors that played into that. But I wanted to just give you both a chance, and I guess it'll have to be brief, unfortunately, with the time I've been allotted. But how does that make the victims' families feel? What sort of an impact does that have on a victim's family when you feel like the accused has more rights than you do as a victim? Miss, I guess we can start with you.
I'm sorry, were you asking me first?
Yes.
Okay. I can guarantee you that the accused has more rights than the victims. Even when we go to court, we're allowed to do a victim impact statement. We have to keep it very brief, but then it is handed in before we actually go, if we're fortunate to get a trial, and the accused and their defense lawyer gets to read our victim impact statement before we're even allowed to read it in court. If they don't like anything in there, they can ask that it be removed as well. We don't have any rights in court, and our loved ones don't have any rights in court. I was told by a lawyer that basically, even because my daughter was only 22, she wasn't married, didn't have any dependents, her life in the eyes of the courts was basically worth zero. I was told that by a lawyer. I was also asked a lawyer if they could ask for a 10-year sentence because my daughter was murdered by this one. And I was told basically that a judge would probably laugh at us and say, well, that's not going to happen. So when I say there are no rights for victims, I mean that sincerely. I hope in the future that will change, but that's the way it is currently right now in our criminal justice system.
I certainly hope that will change as well. It needs to change. And I think we've just got a few seconds. Miss Lucy, did you want to add anything about how that makes you feel as a victim?
It felt like a betrayal by my own constitution. I felt that I have no rights. My daughter has no rights, my family has no rights, but the offender does.
Well, I want you to know that there are people here that are fighting for you.
Thank you.
Thank you, Mr. Richards. Next, Mr. Naqvi for 3 minutes.
Thank you very much, and I also want to start by thanking all of you for being here and sharing your very painful experiences. So we very much appreciate that. I do also want to take about the issue of victim impact statements, and perhaps if all of you can take just very short time to share with us their usefulness or lack of it, and in your view, how can we improve victim impact statements so that they can allow for victims and their families to be able to express themselves in the matters before the courts? Why don't we start with you, Ms. Lucier?
I think victim impact statements have to be one of the hardest statements to write. You're essentially given an essay assignment that outlines your restrictions, how you have to write it, the time frame that you have. So you're trying to compress your life experience into a victim impact statement. And there's so many rules around the writing of it that it becomes more and more impersonal as you go along. And it has to be tailored for the courts. So you're not really hearing the true victim impact statement because it's been vetted by Crown and it's been edited so many times that it just becomes such a cold and sterile experience. I think that where victim impact statements are concerned, I think that they should hold more weight in court, and I know that's not possible, but I think for the amount of writing that people do and the amount of heart that people put into their statements, they believe that it's going to impact sentencing, and again, it's sort of a misconstrued statement. You think that you're writing for your loved one and it's going to make a difference, but really, it's all that matters is case law.
Thank you. Ms. Gold, your thoughts?
I have concerns that the victim impact statement is being edited to that extent, and that's the experience faced by survivors. I think victims need a greater voice and standing in the court process. I had mentioned the option to become a third party, and that way they can have more involvement in the entire process from start to finish, and not just be submitting a statement at the end that gets vetted.
I've got, I think, just a moment left. Ms. Colliers, do you have any further thoughts on how victim impact statements could be improved?
Well, I sincerely wish that they were. Sorry, I wish that they were considered. Most of the times, the plea deals have already been decided on. Sentencing range has already been decided on. People spend hours writing and rewriting this, and then it is taken and briefly read. And does it make a difference? I don't know. It does in sentencing. I don't think so. And I say that because of such low sentences that we have seen. I mean, we've seen for fatalities 1 day in jail, 90 days to be served on weekends only, a $1,500 fine and 7 weekends in jail. And these are all for fatalities. It's ridiculous what's being given out in our courts. Nobody's held accountable anymore for their actions at all, it seems. And families are re-traumatized, not only on the experience of losing their loved ones, the death of their loved ones, but then going through the court system and finding out the sentences are so low. It basically says to that family, your child, your loved one really didn't matter in the eyes of the Canadian criminal justice system.
Thank you, Mr. Nackby. Thank you, Ms. Colas. That concludes the first panel of our meeting. We will now, do we need to suspend it all? Or? Okay. We'll just suspend for 2 minutes, and then we'll resume with the new panelists on. And those of you that are on otherwise can stay on virtually or turn your cameras off, but we'll just do a quick shift change. Thanks. Be resuming the meeting. I think next we have two witnesses. We have from the Canadian Association of Elizabeth Fry Societies, we have Emily Coyle. We also have Mothers Against Drunk Driving, Jamie Lynn Hancock, and Steve Sullivan. So I'll give the first 5 minutes to Emily Coyle.
Thank you, and thank you again to the committee for having me here today. As you probably already know, as I've been here before, the Canadian Association of Elizabeth Fry Societies works to address the persistent ways in which women and gender diverse people who are criminalized are routinely denied their humanity and excluded from considerations of community. Our head office is located on the unceded and unsurrendered Algonquin Anishinaabe territory in what is colonially known as Ottawa. I suppose I would like to begin by stating the obvious. This is not an easy topic to discuss, and I don't need to tell all of you that it is both nuanced and complex. To be a victim of certain types of harm is to be followed by an anguish and a grief that does not go away. Our family has firsthand experience with the pain that is characterized here as victimhood. My cousin was murdered in a gruesome and violent manner here in Ottawa, and more than a decade after her death, we are still impacted by the loss of her in our lives. In my current professional capacity as the executive director of a national organization who works with and on behalf of people who are in the federal prisons designated for women, I am acutely aware that their stories and their lives do not fit neatly into the box of perpetrator or victim, as they are often both. But they are not the people that we traditionally see as model or perfect victims. They are poor. They suffer from mental health disabilities. They are not white. They have been harmed by other people and by systems their whole lives, with little to no recourse for that harm. They are survivors of violence many times over and rarely, if ever, have had the support or therapy for the harms that they have suffered. In conversation with one of the executive directors of a local Elizabeth Fry Society when discussing the provision of therapeutic supports for the people that use her services, she said to me, "Where does one start when the instances of victimization are so numerous?" The myth that there is a clear binary between who is a victim and who is a perpetrator of a crime is ever present in the work that we do. Most people in prison have experienced substantial adverse events in childhood and adulthood. For example, if you look to the Office of the Correctional Investigators research, it has shown that at least half of the people in the federal prisons have a history of childhood physical, sexual, and/or emotional abuse. And those numbers are even higher in the prisons designated for women. By creating a narrative that portrays a false binary between those who experience violence, we are encouraging a system and a culture that does not adopt an informed or responsible analysis of harm. And for example, and this is a key one for us, the majority of street-level crime is inflicted by poor people on other poor people. A solution is not to incarcerate these people in a violent place like a prison. The solution is to ensure that there are no more poor people by eradicating poverty. CAFES has witnessed this false binary narrative having a number of negative incomes, and one of the biggest is the lack of understanding of the justice system, from the charging to trial to sentencing and parole, and this can create false expectations for registered victims. I've seen people who have attended at a parole hearing and have mistakenly equated the denial of parole with justice and the granting of parole with injustice, with little to no understanding of why the person in prison is being approved for release. Secondly, we do need to ensure the safety and wellness of people who have served their prison sentence and reintegrated, but who have registered victims who actively monitor their lives. And in many cases, people leaving prison move to new geographies through conditions of parole or by choice, even if this means living in places where they have little to no community support and have increased social marginality and the real and ironic risk of being re-victimized and reincarcerated. Lastly, we must challenge the prevalence of a certain quote unquote tough on crime narrative that a punitive system keeps anyone safe, when the contrary has been proven to be true over and over again. The body of Canadian and global evidence suggests that punishment and incarceration are harmful for people, communities, and society, and that this model does not reduce or resolve crime. Taking accountability for harm is a necessity. But we really only have one test for accountability in Canada: the length of time that a person is sentenced to prison. This is entirely inadequate and contributes to the feelings of helplessness and hopelessness that is so often expressed by the people who have experienced harm. In our adversarial system, there is no room for a person to express remorse and a desire to make amends. In our adversarial system, we focus only on the punitive and not on the transformative potential of healing and, where appropriate, rehabilitation. In our adversarial system, there really are very few chances for healing. It is for this reason that the most important task here is to be looking to ways that prevent people from becoming victims of harm. I know that I would like to have my cousin here, living and with us. We have to invest in communities that create a world that addresses the root causes of violence and harm. Thank you very much.
Thank you, Ms. Coyle. Now we'll go over to Mothers Against Drunk Driving. Over to you.
Good afternoon. My name is Jamie Lynn Hancock, and I'm the National President of MAD Canada. With me today is Steve Sullivan, our Director of Victim Services. I will be making the opening remarks, and Steve will assist in answering questions. On behalf of MAD Canada, our volunteers and members, and the victims and survivors of impaired driving whom we support, thank you for this opportunity to address the committee on its important work regarding the government's obligation to victims of crime. MAD Canada is a charitable organization with a mission to stop impaired driving and to support victims of this violent crime. Every year, hundreds of Canadians are killed and thousands are injured in impairment-related crashes. For every one of those crashes, family, friends, and communities are deeply and permanently affected. My family knows that impact all too well. On August 21st, 2014, my brother DJ was leaving a tryout for a junior A hockey team when he was hit head-on by an impaired driver. Our parents were at the tryout, and they were on the road just a few minutes behind DJ. They came upon the crash scene and found their son pinned inside his car. DJ died an hour later. He was still trapped inside his car, my parents paying witness to it all. Every day since, we have felt the grief and heartbreak of losing DJ in such a senseless way. It did not have to happen. MAD Canada is the only national anti-impaired driving organization that provides direct support to victims and survivors. We host online monthly support groups. We hold an annual conference for victims and survivors. We provide important opportunities for people to memorialize their loved ones through monuments, online tributes, and memorial road signs. While these hearings are focused on the federal government, it needs to be recognized that most services and rights fall under the jurisdiction of the provinces and territories. It is important that this committee understand that victims and survivors of impaired driving are often not afforded the same level of services that victims of other violent crimes are. In fact, in some jurisdictions, impaired driving is considered a tragic circumstance, and victims and survivors of impaired driving crashes may be excluded from the mandates of government-funded victim services and programs. Many of those who come to MAD Canada were not offered services. They were told there was not much victim services could do, or that they did not meet the parameters of programs. This is especially true for individuals who are injured in crashes. In 2021, MAD Canada held virtual roundtables to discuss victims' rights, and the most consistent thing we heard about was the lack of services, or the lack of helpful services. We rarely talk about the cost to victims when they exercise their rights. Preparing a victim impact statement can be a painful and difficult process. Attending many court or parole hearings can re-victimize people. This is not to suggest we should limit rights, but we must recognize the granting of rights is only half of our responsibility. Providing support is equally, if not more important. In terms of direct services, the federal government is limited to the corrections and parole systems and some direct funding programs. Despite the limited role, we believe the federal government can do more to strengthen federal legislation and support services. The Federal Victims Fund is not accepting unsolicited applications for funding. We tried to apply for support for our 2022 National Conference for Victims of Impaired Driving, which we have done in the past, but we were told new applications were not being accepted. This was before the beginning of this fiscal year. We are asking the committee to make a recommendation that the federal government increase the financial support available through this fund so non-government services like ours can access assistance to provide desperately needed services. Our conference is unlike anything else in the country. We bring 250 victims and survivors from across the country together for a weekend of reflection, keynote speakers, and networking. The impact and importance of this conference is not something I can adequately put into words with such limited time. I can only tell you that my parents and I were so grateful that we experienced this conference after DJ's death. It was an incredible help and comfort to us. We believe that federal legislation, including the Criminal Code, the Corrections and Conditional Release Act, and the Canadian Victims' Bill of Rights can be strengthened to consider the needs and concerns of victims and survivors. For example, more consideration should be given to the mental health of victims and survivors when offenders are released back into the same community. Additionally, the Criminal Code should be amended to ensure victims and survivors receive advance notice of a plea bargain and to require judges to acknowledge victim impact statements in their sentencing decisions. We look forward to participating in the review of the Canadian Victim Bill of Rights. We note that the legislation passed in 2015 called for the review to take place within 5 years, and we are well past that time frame. We look forward to answering any questions you may have for us. Thank you.
Thank you, Ms. Hancock. Now we'll go to the first round of questions. I'll begin with Mr. Moore for 6 minutes, or Mr. McGuire. Mr. McGuire for 6 minutes.
Thank you, Mr. Chair, and I want to certainly thank our witnesses today for their excellent presentations on informing us on the situations that you faced personally and your experiences as organizations on how to, I think most importantly here, help find solutions and better information gathering than what we've had in the past. I want to start off by saying, even to the last panelists, I didn't get a chance to, but I know some of the trauma you're going through, some of them you've talked about 10 years, 15, 20 years. It's 5 years ago this fall that I lost my uncle in a hit-and-run accident, and he was killed instantly. So that trauma never leaves the family. I know that from dealing with my cousins who were left without a father at that particular time, and without a new grandfather as well. So I just want to start in, I guess, asking you, Ms. Hancock or Mr. Sullivan, you know, there's a public perception of the Canadian justice system on Parliament Hill that we've been dealing with now, the topic of discussion recently. Just wondering if you could share with us what the perception of the justice system from the perspective of the individuals and families that Mothers Against Drunk Driving Canada supports. You support an awful lot of victims, and I just wondered what you think their perception is of some of the issues that some of them were named by our previous panel, but some of those, I guess, perceptions of the present justice system are.
I don't think it's all that different than what you heard from the previous witnesses. Many of the families that we work with and support feel that impaired driving is not taken as seriously as it should be, given the trauma that they suffer. We work with people who've lost their children, lost their parents, and in Jamie Lynn's case, lost her brother. We also work with people who've suffered life-altering injuries that they'll never work again. They, have changed how they parent. Their entire lives have changed because of the injuries they've suffered. I think they also feel that in terms of services, especially those people who are injured, for example, here in Ontario, they're not eligible for services in the court system, in our victim witness program. And we hear that across the country. They don't get the kind of assistance that other victims of violent crime, and I'm not pretending that other victims get all that they should either. But there certainly is a feeling that their trauma and the suffering that they've experienced is not taken as seriously by the justice system as they feel that it should be.
Could you add anything to that, Ms. Coyle, as well, please?
When it comes to the people who've experienced the death at the hands of a drunk driver, I don't actually have personal experience with that, with the people that we work with, but I have to say that my heart definitely goes out to all of the people who've spoken here today. And if you are not getting the support that you need, I certainly hope that you do, and that it's listened to.
Back to Ms. Hancock, could you mentioned help to strengthen the provinces. In what way, what would your best one or two items that ways that you think the federal government, that we in the federal government can help strengthen the provinces in the needs of the families and the victims here would be? Or Mr. Sullivan, as the victim, you are the, as I see your title there, victim services.
Sorry,
Yeah,
I was
I-
just going to defer.
Oh, thanks. Sorry.
I think, as Jamie Lynn mentioned, we're talking about victims' rights and services here. That's largely done at the provincial and territorial level. And I think when you look at how those services are funded, it really comes through victim surcharges, right? Through the criminal code or through their own provincial surcharges, which are on Highway Traffic Act offenses. And that's where they get the bulk of their funding. In some provinces, that's the majority of the funding. It doesn't come from taxpayers' dollars. Like governments don't have to make the difficult decisions in terms of funding victim services. It's really with what we can raise from offenders. And I don't think that's a really good way of, if the message to victims is we care about you, I don't think that's a very good way. I know that the federal government does provide some funding for programs and projects, that kind of thing. Obviously, that's an area to look at, increasing that. But those are often short-term funding, try this project, try this funding, it's for 3 years, that kind of thing. I think that's an ongoing discussion in terms of what the federal government can do to help to fund those services. But ultimately, I think it's a decision that provinces and territories have.
The other one, Ms. Coyle, you mentioned that it's the poor, the mental health, there's a lot, the violence. Where does one start then, or where do you think would be your number one solution from a federal perspective? I realizing what Mr. Sullivan just said about provincial responsibility, as we know, but where can the federal government best help in those areas?
Certainly in the provision of funding to essential services, healthcare, mental health care, looking at universal basic income to eradicate poverty. Certainly, one of the earlier panelists had mentioned patriarchy and some of the ways that people are harmed, especially the women and gender diverse people that we work with, by the systems that are both racist and sexist. And so funding is certainly always welcome. But also looking at some of the persistent systemic ways that people are excluded from community so that we can bring them back in.
10 seconds, Mr. McGuire.
Oh, thank you for the time. I'll pass.
Thank you, Mr. McGuire.
Thank you to the witnesses.
Next, we'll go to Madame Briard for 6 minutes.
Thank you, Mr. Chair. My questions will be for Ms. Coyle. During your remarks, you mentioned how important it is for victims to feel protected, as well as offenders. According to your experience, would you be able to tell us whether the current system adequately protects victims and offenders? For example, in the courts. In Quebec, we have something called CAVAC, which is a help center for victims of crime, and there are 17 centers where people from different disciplines come to help victims and their families. And what they say is there are not enough services in place for this protection. I hope you don't mind if I answer in English.
There aren't enough services for victims, survivors. And for the people that we work with, they're often so, and I was just answering to the previous question, they're so excluded from community that they don't often seek those services. They don't think that those services apply to them. They are people that have been criminalized and spent time in jail and prison and often have been continually spending time in jail or prison, and so they don't see themselves as people who are deserving of that support. And I think if we were able to change some of that narrative, it would go a long way.
Pensez-vous aussi que une personne...
do you also think that someone who is better protected would be more inclined to participate in the judicial process because, for example, that person would not have a fear of discrimination or harm?
Really cognizant of the fact that, as many of the people here have said, the judicial system is confusing from the very beginning all the way to the very end. And so even for people who've been trained in the law, it's really hard to understand what something means at certain points in the system. And so certainly if somebody had that support that was both culturally appropriate, that was gender specific, and that understood the background of the people that were going through it, it would be very helpful. I mean, even for people who have degrees and have been sitting at this table in front of you today, for them it was still a challenge. So for others who are more marginalized, it's even more challenging.
Est-ce que c'est... Is it different and worse for women?
The intersectional identities of oppression that people feel, yes.
Et comment faire alors?
What should be done to harmonize access to all of that information and access to all of these services that exist?
But I do think what you mentioned earlier is probably a good start. Look at the local community organizations that work with the people who are most marginalized and try to resource them adequately to provide the support that is needed. And obviously we want to prevent people from being victims in the first place. So, all of this is reactive, but we want to do a lot of upstream work if possible.
Merci. Dans un autre ordre d'idée.
On another topic regarding access to information, do you feel that victims' files, it's too easy for a defense to have access to those? Is there something that could be done in that aspect to protect that information?
Also is very complicated, and a lawyerly answer that I unfortunately am going to give is it depends, because it always depends on the situation and the scenario. I think that I've been a criminal defense lawyer, and the people that I've represented are the people who are in the prisons who've been victims themselves. So it's really tough to give you a straight answer without a specific file in front of me.
Merci. Combien de temps, Monsieur le Président?
Thank you. How much time? 2 minutes? Okay.
On a entendu dire...
We heard that reparative justice truly had a positive impact on the offenders and the victims. Do you think it is possible to protect victims while rehabilitating and reintegrating offenders?
With the consent of the person who was a survivor and the victim of what had happened, if they consent to participating in that kind of restorative justice type of process, then I think that is a really good method of resolving and healing.
Merci. Thank you.
Thank you.
Thank you, Madame Briard. Now to Monsieur Fortin for 6 minutes.
Thank you, Mr. Chair. Mr. Sullivan, Ms. Hancock, Ms. Coyle, thank you for being with us today. Ms. Coyle, I was listening to your opening remarks. Of course, the lack of services is something that all witnesses have been repeating. There needs to be access to lawyers so they can better understand the legal process. There's also a need to help victims overcome these negative events. But I would like to hear you talk about differences from province to province in the services available. Are the same problems that victims have in Quebec the same as in Ontario or BC, and vice versa?
There is no, as you go from province to province, they vary different, and they vary quite a bit. And I think Quebec is actually a very interesting province in that especially for people who are criminalized. They have access to carceral lawyers. They have access to supports that we don't see in other provinces to the same extent. Certainly there's legal aid that does provide some support in Ontario, in British Columbia, but then if you move into the prairies, there's very little support there. So I do think it's across the board very different from province to province.
We also heard during most witness testimony that victims or victims' representatives, whatever the case, would like to participate in certain decisions. I'm wondering if it was actually you who mentioned that earlier. Also, when it comes to plea bargaining in particular, that sort of negotiation, they would like to participate in the determination of sentencing. So that is my question to you. Wouldn't it be a good idea for victims or representatives of victims to automatically participate in all trials? It wouldn't be all victims who would elect to do so. Some victims would prefer not to be involved. Others would want to participate. Would you be able to talk to me about that matter? In your opinion, would most victims choose to participate? Or would most of them prefer to remain outside the system and the judicial process?
Data at my fingertips, other than the numbers of people who are registered as victims currently, which is quite low compared to the amount of crimes or sentences. So I think that we're seeing not perhaps a lack of interest, but a lack of desire to revisit the trauma by participating so fully in the criminal trial. I also think it's hard for people who don't understand the process. As I mentioned earlier, the plea bargaining is a very particular form of law that when participating in it, you would have to really understand the ins and outs of what people are considering there. So I think that would be really difficult for the victims. And then for the people that I work with, they're already excluded from so many considerations of the justice system that, as I said earlier, they don't consider themselves available or to avail themselves of those supports.
Thank you. And we're talking about services. These people need supports, psychological supports, and other support systems. And they also need to be able to consult others to understand the whole process. But when we're talking about the sentencing of the accused and the length of the sentence, could you tell me, does this have an impact on the mental health of victims? Do you believe that victims are all preoccupied by the sentence that will be given, or is that a secondary issue? And
in my experience with the people that we work with, because they are serving time in prison for harm, I think that we have, and I said in my remarks, an opportunity to look at how we determine accountability in this country, and whether a prison sentence is 5 years or 10 years. If somebody is not able to heal because they don't have the psychological or therapeutic supports, then the length of the sentence doesn't matter.
Monsieur Sullivan. Mr. Sullivan, I don't have a lot of time, but I would like to ask you a question. Could you talk to me about the services, psychological services? What is the most important in the services that are being given?
Driving is, in most provinces, victims of impaired driving are not eligible for compensation programs because they're last resort, and many victims of impaired driving have access to insurance and settlements. So, they can sometimes get that kind of support through their insurance settlements, but, they're often, like everybody else, in long waiting lines to get access to professional help. I would say it's incredibly important. And it's one of the things that when we talk with victims and survivors for the first time, it's one of the things we ask them if they have access to. Sometimes they do, and sometimes they're struggling to find it, but it's incredibly important.
Thank you, Mr. Sullivan. Thank you, Monsieur Fortin. Mr. Garrison, for 6 minutes.
Thank you very much, Mr. Chair. And again, I want to thank the witnesses and again for sharing personal stories with us today and reliving those traumas. And I'm going to do something unfashionable as an MP. I'm going to say I learned a couple of things again today. And I'm actually shocked to find that victims of impaired drivers are excluded from victim services in many cases. And I've worked in the criminal justice a long time, but mostly at the federal level. So I understand that's largely provincial. But I wonder if, Mr. Sullivan, you have any suggestions or anything we could do at the federal level to try and tackle that exclusion?
I don't know what at the federal level you could do. I mean, you'll know we have the Canadian Victims Bill of Rights, but every province and territory has their own Victims Bill of Rights, and then they also fund their own services, which are very different from province to province, and so they decide who's eligible for which programs. I mean, I know we used to, going back decades, the federal government used to have a cost-sharing agreement with the provinces in terms of compensation, right? We fund this if you do these things. You know, that might be a solution, but at the end of the day, you know, provinces vary, and some will recognize victims of impaired driving, others will not. Some recognize them as victims of tragic circumstances, which, having come from a community-based victim organization in Ontario, how victims are defined is relevant to your funding. So if these victims walk through your door, you might get more funding. If these victims walk through your door, you might get less funding. So those are really important things, but they're all provincial. And so can the federal government, I think the leverage is obviously funding.
Thanks for that important suggestion. Ms. Coyle, I think you brought an important perspective to the table on victims in that pointing out there's not always a hard line, particularly when it comes to women offenders, between victims and perpetrators. And I just wonder if you could tell us whether there's any consideration, you feel there's a consideration given in the court system to women offenders who have been previously victimized, or is this viewed as irrelevant in those criminal proceedings?
In our experience, each person that comes before the court is different. And so in the case of Indigenous women, for example, there is the GLADU reports that are often ordered. However, the GLADU reports, which are sort of the pre-sentencing reports that look at the social history of Indigenous people, are sporadically available across the country. And in the prairies, where most Indigenous women come before the courts, they don't have access to those. And so that's a real problem for us. Certainly, their experience of being victims in their lives should be brought forward, and that is a good tool to utilize for that, but it's not available. So no is my short answer, and I did give you a bit of a longer answer there.
When you're talking about on the prairies they're being not available, is there a particular reason or problem that the GLADU reports aren't available where they might most be needed?
My understanding from those provinces is that they're not funded and they're not seen as being important or necessary.
That, again, is in the business of being shocked today, unfortunately. So I think the committee will need to address that. You talked about, upon release, women offenders who, many of whom have been victimized previously. You talked about some of the perhaps unintended consequences of the way parole operates for those women. Can you tell us a little more about that?
Yes, for people who are serving long sentences or life sentences, which is a quarter of the people who are in our federal prisons are serving life sentences. Those people are going to be subject to parole conditions for the rest of their lives. And that means that they will invariably have a relationship with the people who are registered as victims in their case. And those people get a lot of information about where they are, what they're doing. And there isn't a great deal of checks and balances with what those people do with that information. It can be leaked to the media, for example, or they could be subject to a harassing letter from a person who is registered as their victim. And, I think in a system where we value rehabilitation and and we are looking to heal, we have to be really careful about how the interaction between people who are serving longer life sentences and the people who are registered as their victims, so that there is no further harm that is caused.
Thank you for that. In women's federal institutions, would you say that in terms of preparation for a release at end of sentence or preparation parole, that there is attention being given to the previous victimization as part of that preparation for release, or not?
So every person who's in a prison has their correctional plan. And in their correctional plan, it does detail some of the past history of the person who is going before parole. So the parole board member will have access to the correctional plan. But often what happens is those are looked upon as risk factors rather than need factors. And so in this case, in our case, we are always advocating for people to get the services that they need, the supports that they need, rather than seeing what has happened in the past as a risk. I'm sorry.
Thank you.
Mm-hmm.
Thank you, Mr. Garrison. That concludes our meeting for today. I want to thank all the witnesses for attending our final session before the summer breaks. So thank you very much for coming. I want to thank all my members of this committee, as this will conclude the meeting. I have a little bit of housekeeping just before the members go. We have a supplementary, a request for supplementary project budget. It was, I think, because we're having in-person witnesses, an increase of $3,500 for this current study. So just want to know if we're all in favor on division. All in favor? Yes. Okay. And I also want to thank our clerk. I think it's his last day today, if I'm right, for our committee, and he won't be here in the fall, so we'll be getting a new committee. So I think we all can give him a big round of applause. And if there's nothing else, enjoy the rest of the week and have a good summer, and we'll see you guys all back in the fall. Thank you.